Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. In this episode, we talk about prisoners who got bailed during the pandemic being asked to go back to prisons. We also talk about why some people in Arunachal Pradesh are opposing the plans for a tiger reserve. But first, we talk about an incident of communal violence that had taken place more than 3 decades ago. This was in Maliana, a village in the outskirts of Meerut in UP. Back in 1987, 68 Muslims were killed there. And only last month, a district court in Mathura acquitted all the 41 men who were accused in the case. In this segment, Indian Express's Anand Mohan tells us about what happened back then and what led to the accused being acquitted. And he begins by telling us that in the lead up to the incident, Meerut district had been witnessing a lot of communal flare-ups.
In fact, the former police officers that we have spoken to over this case have said that there were many incidents which had been taking place which led to communal flare-ups. And so many of these incidents eventually snowballed into sporadic rioting in Meerut, following which, the provincial armed constabulary was deputed to help out the local forces at the time.
Now, a lot of these communal flare-ups were actually triggered after the locks of the Babri Masjid were reopened in 1986, a year before the Maliana violence took place. In fact, even just a day before it, the infamous Hashimpura massacre had also taken place, where around 40 Muslim men were shot dead by the members of the Provincial Armed Constabulary, the PAC, which, like Anand said, was formed to control these flare-ups.
Around 42 to 45 men, all of them Muslim, were, rounded up by the PAC, packed into a truck. They were taken away and they were shot by these PAC personnel. They were all acquitted by a Delhi court, but eventually they would go on to be convicted by the Delhi High Court. 16 of these officials were convicted.
And it is important to note that it was the PAC that was also involved in the Maliana incident. Anand tells us more about it.
Just a day after the Hashimpura case, on May 23rd, 1987, the PAC had turned up and surrounded Maliana village. They had blocked it from all sides. And at this time, violence had broken out. That there was a mob which had targeted Muslim homes in this neighborhood. Homes were set on fire. People were shot. They were stabbed. So over 60 Muslims, including men, women and children, were shot. So that's the case in Maliana.
Anand says that after the violence, a case was filed against 41 people who were accused of carrying out the killings. But it took a long time for the trial court to deliver a judgment. And there are multiple reasons for this, including the fact that the original FIR of the case is still missing. In fact, the court had asked the police for it way back in 2012, and the police took 6 years to reply to the court,
saying that we had sent the original documents along with the FIR and everything, and it is with the court, but the court is saying we never received it. So the police was of the view that, that we can then submit photocopies of whatever in this case. And then the trial court had pulled up the police and had said that around 6 prosecution witnesses have been examined in this case so far, and that they're not able to go forward with this case because of this. So this is something which was quite striking.
He also points out that the case was adjourned hundreds of times during the 3 decades, because of which the verdict got delayed. But talking about the reason why all the men accused were let go, he says that this was mainly because of the doubtful evidence which was produced before the court.
Now, the court had looked into the witness testimonies and had come to the conclusion that some of the accused persons, their names have been taken by the complainants after the police produced a local voters list, and they just picked names from a voters list. That's how these names were taken. In fact, surprisingly, some of the accused persons whose names had been taken by the complainants, they had died way before the incident had even taken place. So the court was of the view that, that the police had in fact just randomly picked up names from the local voters list and they implicated these accused persons on that basis.
And he says that this is not that unusual. In the past, he has come across many instances of shoddy methods being used in the court.
I have certainly reported on cases right from the smallest judgments to bail orders where the courts have figured out that accused persons have been implicated in cases where witnesses have been signing on blank forms, or they are under pressure to depose in a certain way. There is pressure on them. There are sometimes they just come, statements are just recorded, they don't even know what they've said to the police, and the police then are asking them to dictate statements to support the case of the prosecution. So we have come across cases where accused persons have been implicated through shoddy probe practices, and the higher courts have in the past clamped down on such practices. And very recently we just got to see that something of this sort was also employed in the Maliana case.
Now, besides doubtful evidence involving the accused, he says that the court also raised concerns about how witness statements were contradictory and how one of the investigating officers was not even cross-examined.
So then coming over to the fact that crucial medical documents in this case, the prosecution had submitted photocopies of these documents. The court has pulled up the police for this, saying that, that the original documents of the post-mortem reports or a post-mortem register entry, like the original, should have been produced. And since the police did not produce all of that is inadmissible in evidence. So these are some of the reasons why the court had come to the conclusion that the accused persons deserve to be acquitted in this case.
Now, this verdict, after more than 30 years, came as a complete surprise to the families of the victims.
Because nobody was expecting it. Everybody was of the view that there are more prosecution witnesses and more to be examined, and then the case will go on for quite some time, because it had been 36 years after all. It came as a rude awakening. It just jolted them out of their slumber, so to speak, because it's a sleepy hamlet of sorts where people just have set up small shops and, they just largely travel outside for work, rely on agricultural income. All of that, people had just sort of like moved on, especially the younger generation had moved on from this. So which is why when we spoke to a lot of the younger people who were sort of like growing up in that, they were just pessimistic. Now the older people, the survivors that I spoke to, there is disbelief, there is shock, there is also a avid discussion on the judgment. By the time I had spoken to them, they had not received a copy of the judgment. But then everybody was of the view that they were all asking the same questions. Were those post-mortem reports, were they accepted by the court? What happened to a commission which was constituted by the UP government? Did something happen to that? They were just clutching at straws, just looking for answers. There were people who were bitter, people who were of the view that, that we stayed back here, we just had to deal with this. There were so many people who left, so many people have died. They are basically angry over the fact that nobody has been held responsible for these crimes which were perpetrated. They have been asking, who has killed us? Why was there a curfew? Why did the PAC come in? They're saying that, the politicians have come and gone, governments have changed hands, judges have come and gone, police officers have retired and whatnot. But for them, they had to just stay there, wait for 36 years and then finally get an acquittal which left a very bitter aftertaste in their mouth.
But he says that for them, the fight is not over yet, and that they are planning to challenge this verdict in the higher courts.
They have resolved to fight this case. They are going to, first of all, read the judgment, consult with their lawyers, and we will expect a challenge to the trial court verdict before the high court.
And next we talk about Indian prisons. For some time now, prisons in India have been extremely congested. They have been housing a lot more people than they have the capacity for. In fact, according to the last National Crime Bureau's data published in 2021, the occupancy in Indian prisons was 130%. So when the COVID-19 pandemic hit, prisons in the country were in a crisis.
So a week before even we went into the lockdown, there was a crisis moment when we thought about the prisons.
That's Apurva Vishwanath, who reports on law for the paper.
These are closed spaces with lakhs of prisoners. Almost all of our central jails are overcrowded. So this was a situation we were dealing with as we went into the pandemic.
And so at a time when we were being told that physical distancing is important, we knew that prisons were going to be a potential hotspot. And that's when experts started raising concerns.
How do you ensure there are adequate medical supplies? How do you limit the mobility of people within a detention area, one prison itself? And how do you limit the non-essential staff or visitors to prisons? So there were a lot of issues that, we could immediately think of that needed to be addressed. So a week before we went into the lockdown, the Supreme Court took suo motu cognizance of this issue and said that in order to give effect to the right to life of prisoners, and these are mostly under trials that we have in our prisons, right? So at any given point, there are about, say, 1.5 lakh convicts in our prisons and almost 3 times as many under trials in our prisons.
And just to be clear, under trials are those who are kept in custody while their case is still being heard by the court. And Apurva says the reason that the Supreme Court took it upon itself to do something about this is because it is the job of the state to protect the lives of those inside prisons.
So the court decided that we have to decongest these prisons, and there is no other way to ensure that these prisoners would even be alive as we go into the pandemic.
And this was an unprecedented decision.
We talk about decongesting our prisons, we talk about bail reform, we talk about ensuring that our prisons are not overcrowded, but this sort of en masse release of prisoners had sort of never happened before. So what the Supreme Court did was it gave directions to all the states to set up these high-powered committees, identify classes of prisoners who they can release. So that would be based on age, the severity of the sentence, or if they've finished a particular period in their sentence, say somebody has finished 90% of their sentence, so then you could release them. If they were under trials for offenses that have sentences of less than 10 years, you could release them. So, but each jail would have its own conditions, right? It would have its own profile of prisoners. So the Supreme Court sort of decentralized this and said each state would set up its own high-powered committees and they would decide who to release from jails. So between March to May, you had almost all states releasing a lot of prisoners on emergency bail or COVID bail, as they called it.
A lot of people got bail this way. In Delhi, which has one of the most crowded prison systems in the country, about 4,000 people were released.
About 751 were convicts. That means they had been convicted for an offense and they were serving their sentence. The remaining are all under trials. For each state, this number varies. Delhi is one of the most overcrowded prison systems that we have in India. It is the 3rd highest in states and, the highest when it comes to union territories. So in Delhi's central prisons itself, we had about 4,000 people being released between the first and the second waves of COVID.
So this was 2 years ago. And since these 2 years, these people have been living outside the prison walls. But now their bail has been cancelled. In fact, last month, the Supreme Court said that all these people who got interim bail during the pandemic needed to surrender within 15 days. And so that's what they did last Friday. In this segment, we speak to Apurva about this and what the court could have done instead. Apurva, when these people first got bail, there were major health concerns, of course, but were there also concerns that some of these people might not return?
I'm sure there's a fear about, those not coming back to jail. But of course, the bigger fear at that point of time is the pandemic. What if they die in jails was a problem? And that would be the state's responsibility, right? To ensure that they have their right to health and basic facilities and access to healthcare as well. So if the state is not able to discharge its burden, then what is the next best solution? So I think the bigger fear at that point would be to contain the virus. Like it was, the virus overtook and dominated every aspect of our lives. Suddenly, everything else seemed like much smaller worries.
Right. And now, even before the Supreme Court asked these people to surrender, officials had been trying to get these people to come back. So could you talk about that a bit?
So, the MHA had come up with guidelines on broad guidelines or protocols on how to deal with COVID in prisons. So once the first wave was over and these restrictions were sort of relaxed, prisons started calling up people who were released and said, you have to surrender now. A lot of them voluntarily did that. At this point, we still the prisons had not started sort of going out and bringing them back, but, would ask them to voluntarily come back to jails. Some of them did. But when the second wave happened, especially when in Delhi, where it was so bad in the second wave, they were released again. So they went back to their lives. They were out on emergency bail again. And now that there is a broad consensus that the pandemic is sort of over, the prison authorities went to the Supreme Court seeking clarity on this issue and said, what do we do now? They needed sort of this directive from the court to ensure that they all come back to jail. So now it's not sort of a voluntary surrender, but you have to necessarily surrender. Otherwise, you would be in violation of your bail grounds.
And Apurva, you actually spoke to two such people, both of them under trials. Both of them got pandemic bail. Tell us about them a bit and what their lives have been like for these past 2 years.
So we spoke to two under trials who are associated with Project Second Chance. They are an NGO who works with prisons in Delhi, especially in the Tihar jail. So they work mostly in jail number 5, which is a youth jail, where you have a lot of young incarcerated people. So one of them, of course, is a 24-year-old. He's almost a graduate. He has one more paper to clear. So he had been out on bail since May 2020. So what he told me, Shashank, was he's of course on murder charges, but he's been working with Project Second Chance from his time in jail number 5 in Tihar. He says that in the last 2 years that he's sort of been out, he's gotten his life back together. He lives with his aged father. His father has a small business of a chakki, where they grind atta. So he said he's been helping his father with digital payments for the last 2 years. So one of the things that he had to get his things in order was to make sure his father didn't have any of these digital payment apps because he thought he didn't know how to operate them, so he would be defrauded or something of that sort. He had to make sure all of that was taken care of. He was also on his way to get a highway driving license, which he had to go back and cancel. So 15 days to sort of figure out everything was what he was left with. And the other under trial we spoke to was slightly older, 43-year-old man. He has wife and 4 kids. They have seen him in and out of prison during COVID. He also was released from Tihar during the first wave, was asked to surrender, went back to jail, was released again when the second wave happened. Now has, again, 15 days to go back. The second under trial actually told us that he didn't know of the Supreme Court order. It is somebody who was also on bail like this called and said, when are you going back to jail? So that's when he knew that, there was a Supreme Court order and I had to go back.
Okay, so it seems that both of these people have a settled life now. They are working with this NGO. One of them has been helping his father, and both of them have been sort of working within the system. So when you were talking to them and were speaking to experts, did you get a sense that perhaps people like them should continue to be on bail?
So both of them have sort of had steady jobs for the last 2 years. Given that the idea of our criminal justice system is reformative, and you can see that happening, say, with under trials like these, what the court could have perhaps done is to see whether they are eligible for regular bail. Now, because they've been asked to surrender, the onus is on them to go back to prison and apply again for bail. So they will have to apply for regular bail, which is not a very cost-effective way, so to speak. Both of these people told us that they've spent lakhs of rupees already in their trials. And the pace of their trials is also very concerning. Like most of our criminal trials, in both the cases, they were working at a snail's pace. In fact, the first under trial, the 24-year-old under trial told us that it's been 4 years, but he's not even reached a point where witnesses are being examined. In the case of the second under trial, he's booked under the Arms Act. Even charges are not framed against him by the court. So their trial could take another 4 years, for all you know. Even the functioning of courts has been hit by the pandemic. So given all of this, the court could have perhaps looked at whether they're otherwise eligible for bail and then made a call about having them surrender.
And in the end, we talk about a proposed tiger reserve in Arunachal Pradesh. Last month, the National Tiger Conservation Authority announced that a part of the Dibang Wildlife Sanctuary in the northeastern state will soon become a tiger reserve. Now, this proposal didn't sit well with the people who live in the area, the Idu Mishmi people, who are also known as the Brothers of Tigers.
Tigers are very culturally important to the Idu Mishmis because according to the Idu mythology, tigers and Idu Mishmis were both born to the same mother, and tigers are hence the elder brothers of Idu Mishmi.
That was Indian Express's Tora Agarwala, who reported on the issue for the Indian Express. She had written that the Idu Mishmis have their own unique way of protecting wildlife, and the reason why they are opposing this tiger reserve. Tora now joins my colleague Utsa Sarmin to talk about the Idu Mishmis and their concerns.
So Tora, begin by talking about what we know about the Idu Mishmi people.
So the Idu Mishmis are a sub-tribe of the larger Mishmi group, and they live in Arunachal Pradesh and also in neighboring Tibet. They are one of the 26 recognized tribes in Arunachal Pradesh. And in Arunachal Pradesh, they primarily stay in the Mishmi Hills, and this also borders Tibet. And it's a very small tribe, and according to the 2011 census, there are about roughly, let's say, about 12,000 Idu Mishmis. Their language, which is also called Idu Mishmi, is considered endangered by the UNESCO.
Right, and Tora, you have written that Idu Mishmis have a strong relationship with the forest, land and animals, and their way of life actually protects the wildlife. Talk to us about that.
So the Idu Mishmis are traditionally animists, and they have strong ties with the region's flora and fauna. And animals like the hulak gibbon and tigers as well have deep cultural relations with this tribe. And for this tribe, hunting is a traditional way of life. They live near the forest, right? Or most of them live in the forest, in fact. And even if hunting is a traditional way of life, the tribe follows this strict belief system of myths and taboos. And this is called the Iu-Ena. And these taboos basically restrict them from hunting many animals. And there is a complete prohibition on killing tigers. So a number of anthropologists and other researchers have studied the area extensively, and they have said that, this whole system of myths and taboos which restricts them from hunting animals, especially tigers, has led to a unique model of wildlife conservation in the Idu Mishmi inhabited areas.
Right, so their way of life ensures the wildlife in the area remains protected. But what is the reason that they are opposed to wildlife sanctuaries in the area which are also supposed to do that?
Yeah. In the Dibang Valley, there is a Dibang Wildlife Sanctuary which was declared in 1997. And since then, they've been protesting that. They've been saying that this wildlife sanctuary was created without people's consent or knowledge. And they also approached the Guwahati High Court to resolve that. So then the Guwahati High Court had basically said that there should be a committee should be made and they should look into all this. So all this is still happening. But now there is a push by the center to declare a part of the sanctuary as a tiger reserve. This is because in 2012, 2 tiger cubs were rescued in a village called the Angrim village. This is also bordering Tibet. And ever since then, there has been like a series of interventions by both state and non-state actors to determine how many tigers there are or do more studies in this area. And in 2014, the Wildlife Institute of India and the NTCA, together they carried out a survey to determine how many more tigers there are. This was basically a camera trapping survey. They set up camera traps in many areas and they did record a presence of tigers, and this was in like the highest reaches of the Mishmi Hills. So in those snow-clad areas, there were like these really magnificent photos of the tigers. And once they established that, then the case for the NTCA, for the center to propose this as a tiger reserve became even more concrete. So it's primarily based on these WII findings that the case is being made to declare the sanctuary as a tiger reserve.
Okay, so Tora, the Idu Mishmis have been opposing the Dibang Wildlife Sanctuary, and now they're also opposing this proposed tiger reserve, which will be part of that sanctuary.
Yeah, so currently it is a wildlife sanctuary, and in its current form, the access to the forest of the Idu Mishmi community is not really impacted. But now if it becomes a tiger reserve, many things will change. For one, this area will be given stricter security and protection. A special tiger protection force will be made. There'll be more armed guard presence. Now the community feels that this kind of, let's say, militarization of that area will cut off their access to these forest lands. It's very important to remember that these communities, they are forest-dwelling communities. They subsist off the forest. So they believe the moment it becomes a tiger reserve, it will dislodge the Idu Mishmi community from going into their own forests. So they feel that this will cut off access. So that, number one, that is the main problem. And another important point is that the community also says that the WII study, which proved the presence of tigers in those upper reaches of the Mishmi Hills, they claim that the findings of this study is misleading. Because after this study was released, a lot of independent researchers went to those areas and they claim that tigers can't survive in such areas. They may visit these areas for, to catch prey and all, but they don't even survive in those areas. And tigers are living not inside the wildlife sanctuary, but in community-owned forest lands. So their point is, why declare it a tiger reserve when tigers actually don't even really live there? So yeah, these are the number of reasons, but the main reason is the community feels that access to their own forest land, which they subsist of, which they live in, and the fact that, they have this unique conservation model going on for years, and they know how to protect tigers because of their rich, cultural belief system. They feel tiger reserve currently is unnecessary.
Right. So do we know how they're opposing this reserve and whether the government has responded to their concerns yet?
So it's not a protest where they've taken to the streets or anything till now, but they've just released a number of statements. They've also been constantly speaking to the forest department in Arunachal Pradesh. But till now, the forest department, nor the state, nor the center, they've not officially responded to this. So I spoke to the environment minister of Arunachal Pradesh. So he just said that, they'll talk to the center about it. But till now, there has not been any official statement or response to this resistance to the proposed tiger reserve.
You were listening to Three Things by the Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.